Good morning, everyone. Thanks for joining us. My name is Deb Fuster and I'm the Manager of Advocacy and Engagement at the Victorian Council of Social Service, or as many of you know us by, VCAT. I'd like to start by acknowledging the traditional owners of the land where I am today, the Wurundjeri people, and pay respects to elders past, present and emerging, and would particularly like to make sure that any Aboriginal people on this call today feel welcome and safe in this space. This is the 5th Renters' Rights Rundown event that VCOS has run, and I think it's our biggest ever event in terms of the number of registered participants. So thank you so much for your engagement with today's event. We launched this series last year for 2 reasons. COVID happened and the Victorian government brought in a range of emergency legal and financial measures for renters to stay safe at home. And community sector workers were instrumental in supporting renters to benefit from these measures. But also in terms of the bigger picture, as many of you will be aware at a kind of a broad level, over 130 changes to Victoria's renting rules, the Residential Tenancies Act, came into effect on the 29th of March this year. And these changes, which have been long advocated and long planned after years of advocacy from the community sector, we're now living with these rules now. Many of these changes provide specific protections for victim survivors of family violence, and they give renters more options for staying at home safely. And these changes will be the focus of today's session. We know that community sector workers will play a key role raising awareness of the changes and supporting renters to exercise their rights. So we thank you for taking the time out of your day to come to this session, particularly given that it's been a pretty wild and woolly night in Melbourne. So hopefully everyone on this call today is safe and well. We have 2 special guests with us today. Firstly, I'd like to recognise Alison Birchall, our colleague from the Domestic Violence Victoria and Domestic Violence Resource Centre Victoria. And Alison's going to be setting the scene on why family violence workers should be aware of Victoria's renting laws. Alison's going to be followed by Georgia Wooten, our colleague from Tenants Victoria, who is going to take us through what the law provides for when there's family violence. And then finally, we'll have a Q&A session, and we've allocated plenty of time for your questions this morning. So in terms of how these the Q&A session will work, you can submit a question at any time through the Q&A box at the bottom of the Zoom window. The questions will be moderated, as we expect many of you might be asking about similar topics. Please note that the panel won't be able to answer questions about individuals or specific individual circumstances, but we'll be able to talk broadly at that kind of policy level. And we will get through as many questions as possible, but we might not get to them all. And please know that we will take unanswered questions on notice, and we will absolutely follow them up for you. And what we're tending to do with these events is actually post this material online, and we'll send you a link to that after today's session, because even though you might not have specifically asked that question, you probably will be interested in the answer. So we'll make sure that that information is visible to everyone on the website. We'll also ask you to do a quick exit survey that will pop up at your browser at the end of the event so that you can help shape future events that we run. And we'd like to thank you in advance for your input with that exit survey. So now let's get stuck in. As I mentioned, Alison Birchall is our first speaker today. So I'd like to welcome Alison from the Domestic Violence Victoria and Domestic Violence Resource Centre of Victoria. Over to you, Alison. Thank you.
Thanks, Deb, and thank you to VCOS for having me on the panel today. I'd also like to acknowledge the traditional owners of the lands I'm working on today, the people of the Kulin Nation, and pay my respects to elders past, present and emerging, and also to any Aboriginal or Torres Strait Islander people joining in the event today. I recognise that this is and always will be Aboriginal land and that sovereignty was never ceded. So before Georgia provides a more comprehensive overview of the critical changes to residential tenancy law related to family violence, I'm just going to set the scene outlining briefly how we got here. So what does family violence have to do with reforms to the Residential Tenancy Act and development of the RTA regulations in Victoria? So most of you will know already that family violence is the leading cause of homelessness in Victoria, particularly for women and young people. The recent report from the inquiry into homelessness here found that family violence is the main reason individuals accessing homelessness services seek assistance in Victoria. While the trajectory towards homelessness as a result of family violence is varied, it's clear that family violence creates complex risk and safety conditions that have consequences for a victim survivor's housing. The most obvious being that a victim survivor and her children are at high risk in the community and must leave their homes to seek safety within specialist family violence accommodation. Whatever the scenario, losing existing housing can lead to a cycle of homelessness for victim survivors of family violence that can be difficult to recover from and can lead to a series of further consequences related to financial, social, emotional, and physical well-being for both the affected adults and children. While there are a range of programs and responses aimed at assisting victim survivors out of homelessness and back into safe, secure, and sustainable housing in either the public or private sphere, prevention of homelessness as a result of family violence is the benchmark we should all be aiming for. So preserving the residential tenancies of victim survivors of family violence is an important objective for services and practitioners across the government and non-government and specialist family violence and broader community sectors. The Royal Commission into Family Violence in Victoria was a pivotal moment in the history of seeking to end family violence. The Commission's task was to identify the most effective ways to prevent and intervene in family violence and of promoting recovery from family violence. Overall, the Royal Commission found that many different forms and manifestations of family violence were insufficiently recognised, and responses are not tailored to the particular circumstances and needs of diverse victims. This rings true for the private rental market as much as any other setting or system victim survivors of family violence find themselves interacting with. For those victim survivors who remain at home, where their home is a residential tenancy, the Royal Commission found several implications and consequences of family violence for that tenancy. And this slide lists a few of those. So in regards to entering a new rental agreement, the Royal Commission concluded that there was low awareness and utilisation of the existing provision for a person protected by an intervention order, where the tenant excluded from the premises as a where there is a tenant excluded from the premises as a condition of that order, to apply to VCAT for the tenancy to be terminated and a new one made with the protected person. Utilisation of this provision was also limited by the orders needing to be final. In terms of apportioning liability, victims of family violence who were co-tenants were being held liable for rent, property damage, and other tenancy-related debts that were attributable to perpetrators of family violence. For example, a landlord could claim compensation against a victim survivor who was a co-tenant for rent arrears if they fled the property to escape family violence and the perpetrator remained living there. Property modifications. Existing provisions in the RTA allowed landlords to refuse requests for reasonable property modifications to improve safety and security for tenants who were victim survivors of family violence, and the Royal Commission found evidence that this was actually happening. In regards of termination of tenancies, victim survivors who were co-tenants were unable to terminate the tenancy without the consent of the co-tenant perpetrator, or where the perpetrator refused to vacate the property. This was resulting in victim survivors being liable for ongoing tenancy costs after they themselves had vacated the property, and could also be exploited by perpetrators within their pattern of abuse. And finally, blacklisting, where victim survivors' details were listed on tenancy databases allowed under the RTA to record tenant breaches of certain provisions of the Act or of the tenancy agreement. For example, failure to pay rent or property damage, regardless if these breaches were a result of family violence. This blacklisting of victim survivors of family violence created barriers for them leaving crisis and temporary accommodation through accessing the private rental market. So the Royal Commission made 227 recommendations overall, including several related to residential tenancies and tenancy law reform in Victoria. Today, we're focusing mostly on recommendation 116, which was to consider and make changes to address the issues I mentioned in the previous slide in the then existing review of the Residential Tenancies Act. This included a list of specific improvements to be considered, which I won't list here, but I'm sure Georgia will most likely speak to in her presentation. But I just wanted to also briefly refer to a few of the other recommendations related to residential tenancies. One of which was to improve the take-up of existing provisions in the Act for making new tenancy agreements where a co-tenant has been excluded under an intervention order. Also to close the gap between separate proceedings related to family violence and tenancy matters being heard in VCAT and the Magistrates Court, and practice, training and education on these matters throughout the systemic response to family violence, including police, community sector workers and magistrates. So I'll just finish quickly by briefly mentioning the Safe at Home approach to family violence. DVVIC and DVRCV, and indeed many others, believe that as a principle, a Safe at Home approach is the preferred housing response to victim survivors of family violence. Safe at Home refers to a variety of interventions that enable victim survivors to remain in their home while the perpetrator of family violence leaves. Safe at Home responses to family violence and housing must be risk and safety informed, and therefore won't necessarily be appropriate to all people experiencing family violence. However, this response, especially when implemented in concert with case management support, safety technologies, and supported by key justice measures and intervention with perpetrators, has been successful at minimising housing insecurity for victim survivors and mitigating other long-term impacts of family violence on them. These reforms to the RTA provide critical enablers of a Safe at Home approach and contribute significantly to addressing policy shortcomings that have previously constrained the success of this approach. Thank you.
Thanks so much, Alison. It's a really great piece of scene setting by you. Thank you. It's a really great start to the event. Now, I know that more people have joined the call since we started at 10 a.m. So just to let people new to the call know, and just a reminder to people who've been with us since 10 a.m. that there is a Q&A box at the bottom of your screen, and feel free to start populating that with questions, and we will get to that at the end of the two formal presentations. So the Q&A box at the bottom of your screen. Now I'd love to welcome Georgia Wooden from Tenants Victoria. Thank you, Georgia.
Thank you, Deb. Good morning, everyone, and I'm so thrilled to be a part of this Renters' Rights Rundown. As introduced, I'm Georgia. I have been part of Tenants Victoria since 2018, and you can imagine that's been quite a ride. We've had the 1997 Act, we've had the COVID emergency measures, we've had some early introductions to the amendments, and then we've had the full introduction to the amendments. So it's been definitely a wild ride. Today I have 13 slides for us, and I think it's going to take about 20 minutes, hopefully. And I just wanted to thank Alison. That was an exceptional overview. And I also just wanted to say broadly that talking about family violence can be really confronting. And if anything in today's presentation is triggering or upsetting, just take a moment. All of this is going to be online. Go and get a cup of tea or a glass of water. Be gentle on ourselves. This can really bring up things that we didn't know existed. So let's get going. I would also, as a presenter today, like to acknowledge the people of the Wurundjeri, their elders past and present and emerging. And I want to extend that respect to any Aboriginal and Torres Strait Islander people here today. While I am giving my acknowledgement and paying my respects, I would also just like to mention about VCAT's Koori Court, if you're not aware of it already. The VCAT has two particular things that might be useful for Aboriginal and Torres Strait people so that they feel culturally safe in this area. And one of them is the Koori Court. You can ask to use the Koori Court. It has been smoked and it is a culturally safe place for you. There's also a mobile number if you want to have a yarn or talk about a current VCAT matter or a VCAT matter that you think will be coming up. And I'm just going to read out that number. It's on their website, but just in case you want to jot it down, it's 0417 516 335. You can text that number or you could call it. It's there for you to use. I have to do a legal disclaimer here. I know Deb mentioned it already, but the presentation today can't be substituted for legal advice. What the presentation today is about is to support advocates and workers who assist renters in the family violence sector. It's going to be a small overview, but it's going to be some very useful information, and I want it to equip you as advocates. I want to stress that you don't have to know any of these section numbers. It's just about having that seed planted so you know that there's something out there that can assist tenants. I'd also like to make mention that if something is raised today that you thought, actually, I've got I need some help, there's some legal advice a tenant would benefit from, we have 10 lawyers at Tenants Vic, and every single lawyer is listed for one day to do what's called an organisational advice. So call our reception, the number on the screen, and we will return your call that exact same day. So you won't have to wait very long to speak to an experienced lawyer. Okay, so just as a bit of an introduction, this overview aims to identify the main remedies that are available to renters under the new amended Act. And like I said, I don't want you to walk away thinking about section numbers. I just want to plant these seeds so that renters know that there are specific measures that are out there that they can take when their tenancy is affected by violence. Some of them are not very well known, and some of them you've probably heard of before, and so we'll recap on those. For me, if we can just spread the word that these remedies are out there and they exist now when they didn't before, that is going to be a huge benefit for the community. And these protections are there and they need to be taken advantage of by tenants. So I'm really looking forward to sharing them with you. Now, as Alison touched on, these new amendments are there to help prevent and reduce the well-known consequences of family violence within tenancies. And my experience is when affected renters know that they have rights and when they know that they'll be supported by the law, it gives them choices. And it places some power back within themselves to make informed decisions about their family and their tenancies. For example, if they don't know they can stay, homelessness might be an alternative. And if they didn't realise that they could get out of the lease, then rental debt is a very likely consequence. Alison touched on it before, do renters know that that database listing that's there, that's preventing them from finding homes? Do they know that they can get that removed if it was because of family violence? And just to repeat, that is the purpose. These new amendments are going to help prevent these consequences. Okay, so today I'll be talking about the affected person. That's a terminology I'm going to be using. I'll also try to correctly use the terminology of renter and residential tenancies provider. I may slip up. Old habits die hard, but I certainly will try. So affected person, renter and residential rental providers may be new terms for people. Okay, so let's get on to the practical things. You know, what we can do to help support renters, help support them, themselves and their families. And I'm going to focus on a few things today. I would like to firstly focus on when renters want to stay. And what we'll talk about there is locks and modifications and creations of tenancies. And then we're going to discuss the options to leave. And that's when we'll talk about a very new reduced notice of intention to vacate that can be used. And we'll talk about a couple termination applications that are available for affected people. And the purpose of this is to help tenants decide what avenues they might want to take. And as advocates and workers, there's some questions that we can ask to help the tenants make those decisions. And again, if anyone has any questions during these, pop them in the Q&A, and I look forward to joining the panel, and we'll see if we can try and answer them as best we can. So let's get into it. So, like I said, I'd first like to talk about renters' rights when they want to stay in their home. We know that an affected person might need to change the locks, and this is obviously to ensure that they're safe and they're secure in their home, which is absolutely paramount. We often have questions from renters and from advocates alike, and the question is generally, do we need consent? So I'd just like to speak to that for a moment. And I will repeat a couple of things just to make sure that we're all really clear. The first thing is consent is not needed to change a standard lock. Consent is not needed to change a lock that's part of a master key system, like a key that opens many doors. You don't need consent to change a master key lock if you have an IVO or if you have a VCAT order that creates a termination or creates a tenancy. So even if the renter is not listed on a lease, if you have an IVO, you can change the locks without consent. These are huge changes. And there are important mechanisms to keep families safe in their homes. It's a way to remove a perpetrator. And like Alison said, it can stop that cycle of homelessness that affected persons face in situations of family violence. So that's a big change, and we might have questions about it later, but I'm just going to speak additionally in respect to modifications. You don't need consent, and this is also new. You don't need consent to install security lights. You don't need consent to install an alarm system. And you don't need consent to put in a security system that you can do yourself. In fact, you don't even need an IVO to do any of the above modifications. These are called safety modifications, and they're available to all renters. I will make mention that, some modifications will need consent, and I'll just give you a couple examples. They might be obvious. If you wanted to secure, like install a secure letterbox, or if you wanted to make changes to an existing external fence for safety, you would want to get written consent for that. And as advocates and as workers, we need to support tenants to change the locks when they need to be safe. And we can also support them to get consent from the rental provider if they want to make modifications that need that consent. It'll also be important to note that if you are making a modification like this, you'll need to restore the property or just get consent from the owner, whether or not it's okay to leave those things there. So there are some really big changes in the Act. There certainly are some rules around when you do need consent, but I just wanted to share those most important moments when consent is not needed. If there's safety at risk, change the locks, put your safety modifications in. Okay, so the next topic I wanted to raise is the very underutilized mechanism for ending a tenancy rather quickly. And this is when the affected person is listed as a renter on a lease agreement. So if the affected person leaves and they have to go to crisis accommodation, for example, I imagined last week we assisted someone that went into Safe Steps temporary crisis accommodation. They are able to leave their home within 14 days. They do have to give the proper notice of intention to vacate though. So if you're assisting a renter, you can support them in making sure that they give the formal notice, and it's called that notice of intention to vacate, and it's on the Consumer Affairs Victoria website. In fact, the form is brand new and there's a tick box for this exact reason. You do have to make sure that they have evidence, so a letter from a support worker or the crisis accommodation would help. And it doesn't matter if the affected person is on a fixed term lease or a periodic lease, it will reduce it to that 14 days. They cannot be charged break lease fees for using this notice to vacate. And one of comment is that using this means that there won't be that liability. Yes, you'll have to pay the 14 days rent, but that is often a better alternative than to the lease break fees that some people might be liable for. So let's move on to my next topic now that you know about that avenue. So this is probably my most utilised section as an outreach worker at Tenants Vic. This is the all-encompassing section 91V. I said you don't need to know sections, but this one's a good one to remember. It gives us so many options. It provides a method to terminate the tenancy, but it also gives rise to creations of tenancy, which is oh so important. There are some important parts, which are, and I'll read them off the screen, that the perpetrator of the family violence must be listed on the agreement to utilise this section, and there is no IVO required if there's family violence. But if it's personal violence, you will need an IVO. The affected person can seek for a creation of tenancies, and they have also that option, like I said, to end the tenancy here. And this all-encompassing section means that when you get to that hearing, VCAT can also deal with unpaid rents, unpaid utility bills, any damage to the property, a bond, and the affected person can also seek orders about database listings to make sure that they're not listed because of the family violence or any debts. And as a huge relief to so many people that are worried about this, they can't be pursued for lease breaking costs when they end their lease or under this section. So if you're assisting a affected person in making an application by this type, just a couple tips from someone who's done it about 50 times. Start by using the right form. VCAT has a purpose-built form for this exact process. It's called an application for a person experiencing personal or family violence. It's a bit of a mouthful. But that application is on their website, and it's a 15-page form, and it deals with everything tenancy related where there is family violence involved. And sending and using this form to VCAT will also connect the affected person with the family violence support worker in VCAT. There are two at the moment, Joe and Carly, and they can provide really important non-legal assistance and support to the affected person about their application. And that's support before the hearing, and it's also support during the hearing if they'd like that. Importantly, which is not listed on this slide, is that hearings under this section will come up very quickly after it's lodged. VCAT will list this hearing within 3 days. And this is an incredible turnaround for VCAT. And I think that it really goes to the heart of the community's expectations here, that protecting the affected person is of paramount importance. So there'll be lots of questions about that, but we'll keep on going. So I'll just go on to my last major points of discussion for this presentation. And it's another termination method, because not everything will fall into that 91V section. And it's terminating a fixed term rental agreement because of severe hardship. Like I said, the alternative, and the reason that it's the alternative is you can use this section where the perpetrator is not on the lease. And here, VCAT will have to make some different considerations, such as whether or not the affected person's hardship is greater than the rental provider's hardship, a different test. However, my experience is that it's not controversial to VCAT that family violence is indeed severe hardship. And I haven't been in a hearing where VCAT have said otherwise. So some of the risks in this application, though, is that there's no blanket rule of no lease breaking costs. However, again, in my experience and in our position at Tenants Victoria, that there certainly should be no lease breaking costs if it comes to an affected person leaving because of severe hardship based on family violence. And we've been successful in seeking orders to protect the affected person's bond under those two sections there. If you have any queries about that, this is something you certainly should send the tenant to get legal advice about. I'd also just like to touch on some general notes about VCAT hearings where there is violence. Firstly, if it's preferred, the affected family member or the affected person, they can ask for a telephone hearing if they don't want a face-to-face hearing. And where they would like a face-to-face hearing, they can also utilise the remote witness room at VCAT. The other thing is, it can be daunting for an affected person to have to serve the documents on the other side, particularly when the other side is the perpetrator. using that VCAT form that I told you about before, the protected persons form, there's a box you can tick. The VCAT family violence worker, they will send it and serve it on the other side for the affected person, so they don't have to. And lastly, at the hearing, it is daunting that the perpetrator is going to be there, and there are specific rules in respect to the VCAT Act and the Residential Tenancies Act to stop the perpetrator asking questions or cross-examining the affected person. So those are there to try and help it being a more safe space for the affected person. And I just wanted to do a quick shout out that we have an updated family violence kit. It's coming really soon. We hoped it would have been ready today, but it's just a couple weeks late. So it is an invaluable reference for workers and advocates alike, and even tenants. It's going to look fantastic with our new branding, and it'll have just a couple of things that are in it. It has a list of questions that you can ask. There's information on intervention orders, there's tips on how to prepare for the hearing, and heaps more things. So a quick last thank you. I wanted to say thanks to everyone for joining us today, the audience, and I'm really excited about joining the panel to help ask your questions, or answer your questions. So that's it from me.
Thank you so much, Georgia. Another great presentation. And as a non-lawyer, can I just say thank you, Georgia, for really kind of breaking down very complex information and being really aware of the audience today. I found it a really terrific presentation. So thank you so much. Now we're going to do a Q&A session, and so Georgia will participate in that, which is fantastic, and our colleague Alison from Domestic Violence Victoria, the Domestic Violence Resource Centre of Victoria. So Georgia, I think you and Alison, I'll invite you to switch your cameras back on. We'll keep your mics on mute, and I'll let you know if the question is directed to you. A heads up, Georgia, the first question that we've got is going to be lobbed to you, and Alison, the second one to you. So thank you, and keep those questions coming. We've got a bit of time up our sleeve, so use that Q&A box. So for Georgia, the first question is, what provisions are in place to support renters who are left with rental arrears when the perpetrator has removed themselves from the lease? And there's a qualification there, when they had also prevented the survivor from working while in the relationship.
Oh, that's a very big question. Do we have an hour? This is an excellent question. It goes to the heart of why these amendments are there. And one of the frustrating things is that it does not, and we're finding the holes of the amendments of when they don't work. So one of the issues is that if a perpetrator has left and the tenant is on the lease and she can't afford the lease, it puts our affected person in an extremely difficult position. The important thing here is remembering that the perpetrator who's left, if they're still on the lease, they're still legally liable. So there's a couple options available for this woman. We could continue to make them liable, get a court order, a VCAT order to say that they're liable and enforce them to pay the rent. Or there's other options as well, but when you're both on the lease, you're both jointly liable. So my suggestion would be not leaving it, but getting specific orders to identify who is liable for what, because we need to make sure that the responsibility of the tenancy does not just fall on the tenant that's left there because of family violence. The responsibility must also be shared to the person who's created the situation.
Thanks, Georgia. For Alison, the observation, the question is, I work with women that have experienced family violence on temporary visas. They're waiting for a permanent visa outcome. Due to their visa status, most of them are not eligible for financial support. Is there any financial assistance for them that you know of, specifically around bond?
Yeah, thanks, Deb. Look, I think everyone recognises that the situation that victim survivors of family violence with temporary visa status find themselves is quite critical in Australia at the moment, and there's plenty of people doing a lot of hard advocacy to try and address the structural barriers that they face to support. Fortunately, in Victoria, we have flexible support packages, so that's really made a difference in this state to the type of support that we can provide to people in this situation. So flexible support packages are available to adults and children who've experienced family violence up to around $10,000. In addition to that, where victim survivors are in specialist family violence accommodation, so a refuge, there has been a small state government grant program to try and support them with some of the costs and expenses that they face, that they're not able to access social security, etc., to meet the costs and to address their needs. And finally, just before the federal budget announcement and in the recent budget, and was extended in the recent federal budget announcement, there is a payment pilot program that the federal government have set up for victim survivors experiencing family violence of around $3,000 each, which isn't a lot of money, I know, but it can be used for expenses like housing and accommodation expenses.
Thank you, Alison. Now, Georgia, the next question's for you, and it's some questions clarifying information about locks. There's about 4 kind of sub-questions or interrelated questions. So, Georgia, what I might do, and for the audience as well, I might run through all 4 questions, and then, Georgia, we might break it down and I'll kind of repeat each specific or discrete question in there. So the span of information that our audience member is asking about in terms of locks is, am I right in what I heard earlier that it does not need to be a final order for the locks? What if there is no IVO? Is the renter responsible for paying for locks and any damage caused by locks being installed? And finally, does the new key have to be provided to the landlord? So if we go to the first bit of that question, am I right in what I heard earlier that it does not need to be a final order for the locks?
Correct. You do not need a final order. You don't need an intervention order. If there is a safety concern and it's an ordinary lock, you can change it.
Fantastic. That's the first 2 bits of the question dealt with. Thank you, Georgia. And is the renter responsible for paying for the locks and any damage caused by locks being installed?
Excellent question. I'm really glad. I actually imagined this would be a question, so I wrote a little note to remind myself. In respect to paying for it, you do have to pay for it yourself. However, I've got a few notes about how you might be able to alleviate that cost for the affected person. So there is financial help to get the locks changed, and a lot of the workers here might already know about them being in the community sector, but there is the Victorian Government's Victims of Crime website. There's also the Domestic Violence Resource Centre of Victoria, and there's a couple other financial avenues as well. But importantly, and I just wanted to stress this as well, if the affected person lives in public housing, we have been successful on getting the Department of Families, Fairness and Housing to pay for those changes as well. And I actually remember that last question. It was in respect to fixing the locks, any damage, the locks.
Yeah, that's right. So the other bit of that third question was, are they responsible for any, is the renter responsible for paying for the locks and for any damage caused by the locks being installed?
The answer is yes to that. And again, I would pushback to say that make sure that if they need financial assistance, that's useful. There was that last question as well.
That's right. It was finally, does the new key have to be provided to the landlord?
Yes, it does. As soon as practical. It doesn't need to be that moment, but yes, as soon as practical. And I'll just add, if there's anyone else that lives in the property that's not the perpetrator, you'll also have to provide a lock to that person as well, because they have a right to it.
Thanks, Georgia. Great set of questions there, and excellent comprehensive response. Really clear. Thank you, Georgia. The next one is for Alison, and the question is, what obligation does a housing, if any, so what obligation, if any, does a housing provider have to fund security modifications for the safety of the renter if the renter is not in a financial position to do so? And the person asking this question has observed, for example, it can cost more than $300 to change locks or install CCTV cameras. So if they're not a housing provider, are there any other options?
Thanks, Deb. Yes, I think this question flows on nicely from the ones that Georgia was just addressing. My understanding is that the rental provider doesn't have an obligation to cover those costs. But again, there are programs available in Victoria to address that. So once more, the flexible support packages are there to provide financial assistance with any security measures, particularly those that are under the Personal Safety Initiative. So in Victoria, the Victorian government has set up a program whereby victim survivors and children who are receiving support related to family violence, who have a case management plan related to family violence, can access financial assistance for safety and security modifications at their property, which would range from security cameras, changing of locks and other security modifications, security doors, etc. If anyone wants any further information about that, it is available online, but also at DVVic, we have the Personal Safety Initiative statewide coordinator who would be able to provide further information around that. Also, any other specialist family violence service, your local specialist family violence service would have information about accessibility to that as well.
Thanks, Alison. And just probably relevant to note here, we've mentioned a few times that we will provide links of this recording, a transcript, etc., following this event, and we'll make sure that we're working with our colleagues at Domestic Violence Victoria and DVRCV and Tenants Victoria, just to make sure that we're incorporating some of the links to information resources that Alison and Georgia have mentioned today, so that you're not having to scramble through your notes after the event and be Googling. We'll make sure that we provide a comprehensive set of links to you. So thanks, Alison, for that information. Georgia, there's a few questions that are coming through around consent for safety modifications. One of these is, can you please explain the process to gain consent for different types of modifications? For example, CCTV that is hardwired versus other types of CCTV, alarms, etc.
Certainly, thank you. And even in the Residential Tenancies Act and the regulations, things are very broad. So, for example, we have an example of a security camera where you don't need consent, but then I've also made note where that if it's a security system that needs to be hardwired to your electricity, that needs a qualified installer, then the renter should get the consent. And so you don't need it if you're just popping it outside and clicking it in, but if it's going to be hardwired, you would need that consent. So one of the things that I would suggest is there's no formal mechanism or proper form you need to be consent. As long as it's in writing and you're clear about what is happening or what the modification is, an email will suffice. That will be okay. If you want to write a letter, that's okay. A practical thing that I've done is I've drafted up drafted up a letter. You don't need an IVO, but if you've got one, attach it to your email, let them know what you're doing. And that puts the agent and the rental provider on notice to say, this property has been affected by family violence. We're making some significant safety changes, modifications. In my experience, we haven't, particularly for public housing, we've never had much pushback. But that mechanism is there, that if you do receive pushback, if they say, oh no, I don't want these security lights to be on, you still have a remedy by making an application to VCAT. It'll be listed within 3 days. You can get an order from VCAT saying, yes, these modifications are necessary for the safety, and they'll list what modifications you can make, and then you can go and make them without the consent.
Thanks, Georgia. A few more interrelated questions around modifications, Georgia. So I'll start with, where modifications have been installed without consent, would these need to be removed in order for the tenant to leave the property in the same condition?
That's an excellent question. And it actually, it doesn't matter whether it's consent or without consent. It is the renter's obligation to remove the security, the safety measure before they leave the property. So it's in the same condition. However, we have had instances where the landlord, or I said the wrong thing, residential rental provider, has consented to them leaving it there because they wanted it there. But you do need to double check. Do they want you to remove it, or do they want you to leave it there? You can remove it if you'd like to. You are obliged to remove it unless they consent to you keeping it there.
Thanks, Georgia. And another really great question, all these are interrelated, it's excellent to be unpacking all the different dimensions, is if there's a modification such as security lights that's not removable, would the tenant be liable for the cost of restoring this back to the original state if the landlord does not wish for the security devices to remain?
Absolutely, absolutely. And if you were getting funding for this, that might be something as a worker that you would flag to say, we know we're allowing funding to get this put in. Can we just highlight that we might need funding to restore this when we leave as well, so that that cost doesn't go back to the affected family member?
Excellent. Thank you, Georgia. Georgia, another for you is my client's rental application was declined as they did a credit check and found that the perpetrator has a $70,000 debt that he's put in my client's name. Are there new laws in place now where she can challenge this?
Certainly, there are. It is I don't know the section off the top of my head, but there are two. One of them is, it's a specific tenancy database listing. You can make an application under a protected persons application. I did this 2 weeks ago. I don't know why I don't remember the section number, but you can make requests that, because the tenancy database listing was in effect due to the family violence or the personal violence, VCAT can order that that gets taken off. Certainly, I've only seen it done a couple times since the new Act is there, but I want to use it more. These women need to get off this tenancy database listing. So if you're interested in running some, please contact Tenants Victoria. We might be able to give you a hand.
Thank you. More and more questions coming in around modifications. So, Georgia, is there an amount of time that the landlord needs to respond to a property modification for consent or non-consent? Person has observed, our problem is that they just delay in responding.
Yeah, that's an excellent question, and there is no answer to the time frame. I have some practical experience where if it's in respect to a lock, we just get it changed. It doesn't matter. If it's in respect to a modification, generally speaking, putting the modifications in, it takes some time to get the qualified person to come out anyway. So what I've been doing is I've been booking them in, and if the consent hasn't come within a couple of days or before that person attends, following up, say it's been 3 days, and if not, I'm lodging that VCAT application immediately. We don't want the affected person to get a breach of duty notice for which is quite unlikely, but we just want to prevent any further escalation of this. So my suggestion would be a reasonable time is probably 3 days, given that it is a significant security measure, and a couple phone calls to not harass but remind them would be worthwhile as well.
Thank you, Georgia. And Alison, just to make sure we're bringing you back into the conversation as well, just some great pro tips there from Georgia, but from your perspective as well, as Alison, do you have any suggestions for how workers can move the process on?
I think, standard practice around keeping in close contact with the victim survivor in that period and monitoring the fluctuations in their safety during that time. 3 days perhaps doesn't sound like very long to a landlord or a real estate agent to respond to these requests, but a lot can change in terms of the dynamic nature of family violence in that time. So monitoring that situation and putting safety plans in place and escalating the request as required. So I think definitely getting in touch as early as possible with some legal advice, providing all of the information you can to the client, keeping them informed while they're waiting for the response.
Thank you so much. Now, the next question, Alison, I'll direct to you as well. And I think we've touched on elements of this in some of the earlier Q&A, but this sounds like it's a question that's coming from Melbourne's southeast. And the kind of the scenario that's described here is that the person is working, sorry, my screen's just flicked. Sorry, bear with me for a second. Bear with me for a second. Sorry. The person is working as a support worker. Most of the clients that the worker has are homeless or don't know where to go. Just wondering, so to help them with that, is there any fund that they can help us to assist the client, or a program that I could refer to them other than Ways? I'm just wondering with that one, Alison, whether the answers there reside in some of the links that we'll provide as a bit of a follow-up to this event in terms of, funding pools that are available, packages that are available, etc., and some of the go-to places that can assist the people on this call who are working to support victim survivors of family violence. But just wondering if there's anything else that you want to add there, Alison.
Yeah, I mean, I think your local family violence service, so in this example, Ways, is probably always the first port of call, and probably the place that you have existing relationships with and knows the kind of geographic location and other services around. I think always we would suggest that people go through Safe Steps as well, the 24-hour 7-day-a-week crisis service in Victoria, who can also facilitate access to crisis accommodation and temporary accommodation. While these are not necessarily ideal types of accommodation for people who are at risk as a result of family violence, it is a stopgap there that can provide that type of support.
Thanks so much, Alison. Now, this is the last question we've got time for, unfortunately, but as we said earlier, we will pick up calls that, questions that we weren't able to get to, and we'll follow up with responses. So the last question for Georgia is, when a lease is under two names, the perpetrators and the victim survivors, and there is an IVO that's excluding the perpetrator from the home, can the perpetrator remove their name from the release without the consent of the victim survivor?
That's an excellent question, and potentially they could. And the mechanism that they would use is an application under Section 91U, which is terminating the fixed term tenancy for severe hardship. They would have to convince VCAT that it was reasonable to make that order. My suggestion is, if that you were supporting the affected person in that sense, that we could provide her or him, they, options to how they might want to circumnavigate that. But it's also an important note to say that we do often also represent clients that are the perpetrator, and there are mechanisms for them to get out of a lease as well, and that's the 91U application.
Thank you so much. I'm sorry that we've run out of time, but I guess this is a really strong signal to us that we were right in terms of our instincts. Georgia at Tenants Victoria, Alison at DV Vic, and VCOS in thinking that there was the makings of an event here today in terms of running people through some of the information about the new rental laws. So I'm really glad that we've convened this. I'm really sorry that we didn't get to all the questions. I promise that we will take all of these questions. We won't lose any of them, and we will come back to you with responses. And, you know, if there's need to do so, we will also kind of come back and perhaps convene another future event. Also just wanting to acknowledge and note that Tenants Victoria will be running out their formal training program to the sector in due course as well. That is top of mind for everyone. So thank you so much to my colleagues Georgia and Alison. It's just terrific to be partnering with you. Thank you to everyone who participated today. Thank you to our Auslan interpreters, our captioners, and I really do want to pay tribute and acknowledge my colleagues behind the scene, Karen Taranto, our Housing and Justice Policy Advisor at VCOS, and Amy Houston, who is the glue in our communications team as well and helps us with all our events. There is so much hard work that goes on behind the scenes, so thank you to the terrific VCOS crew. Tenants Victoria partnered with us for a number of renters' rights events now, so thank you again for their excellent expertise on these subject matter changes, on these important changes. Thanks to the Department of Justice and Community Safety. Our events are made possible by the support of the department, so we're very appreciative of that. Also like to thank all members of our Rental Fairness Stakeholder Group, who've been a driving force behind our rental fairness sector communications and engagement. And just a reminder, I know that we're just running a little over time, but if you could please take a few moments to complete the event survey when it pops up on your screen, that will really assist us. We'll be back in touch with you with a full transcript, caption video within a few days of this event. We'll post it to the same webpage and we'll send you an email when it's ready. So please remember also to follow VCOS on social media and sign up to our email alerts to learn about future events like this one. And I'm going to slow down my speech now and say thank you so much. Have a lovely day. Stay safe and well, everyone, and goodbye. Thank you.